To the 2024 DLA Piper Canadian Data Protection, Privacy, and Cybersecurity Symposium. My name is Tyson Gratton, and I will be the moderator of this session, Privacy and AI, Where Are We Now? Thanks to everyone who submitted questions in advance of this session. We have strived to include as many as possible in the time we have today. We'll, of course, leave a spot of time at the end for any additional questions you may have. Be sure to pop those into the Q&A feature, and we'll take a look at those in the last 5-10 minutes of our presentation. And of course, all of us are happy to chat afterwards to discuss your questions more in depth, so please do reach out to any of us. Panelists, thank you so much for joining us. Carrie, can you mind kicking off the introductions?
Absolutely. I'm thrilled to be here with all of you today. I'm Carrie Bennett. I'm counsel here in Vancouver and a member of the Privacy and Cybersecurity and Data Protection team, and excited to be talking about all things privacy and AI.
Awesome. Thank you very much. Shea?
For sure. Hi, everyone. Name is Shea Coulson. I'm a partner here in the Vancouver office, where I'm involved in the Canadian AI group, and also as a litigator on technology and technology-related issues, among other things.
Awesome. Thanks so much. And last but not least, Ryan.
Well, until you introduce yourself, Tyson. Hi, Ryan Black. I'm a partner in Vancouver here. I actually practice mostly in video games and interactive entertainment. However, AI is a big part of that. I'm more generally a tech lawyer. And I'm on the commercial side, so I deal with commercial agreements and internal company policies and that sort of thing.
Thanks, Ryan. And myself, as mentioned, I'm Tyson Gratton. I'm a senior associate in our media sports entertainment team here in Vancouver, also primarily focused on consumer software, consumer media, particularly video games. My practice is also commercial and regulatory with a focus on all things consumer regulatory, so consumer privacy, marketing, protection, and artificial intelligence in all the many ways it impacts pretty much all of those areas. So thanks so much for coming, everyone, panelists and guests. And now that we're all acquainted, let's get to it. We're going to start with a bit of a regulatory update to kind of set the stage. As many are aware, the federal government introduced Bill C-27 way back in 2022, which wasn't the first time they've tried, which would both overhaul consumer privacy law in Canada and institute Canada's first AI-focused legislation, the Artificial Intelligence and Data Act, or ADA, as we'll call it. Ryan, what's the status of ADA currently, and Bill C-27, I suppose, more generally? Have there been any substantive changes as ADA works through its way through the committee stage? I'm curious to hear thoughts about, as well as time ticks on. It's kind of starting to seem a little less likely that this will be passed before the next federal election, but curious to hear your thoughts.
Yeah, there were a few roadblocks that kind of came up when ADA was introduced. First of all, it was introduced kind of as a subset of an overall privacy overhaul, which has itself taken a lot of air out of the room as parties debate and as the parliament tries to figure out how to pass that thing. And then the other thing, of course, is that the march of technology continues on, and AI a year ago is quite different than AI it was 2 years ago, and certainly different than it is now. And so those impediments have kind of hit ADA squarely on. And so, you know, the important thing to understand is that if you go to look at the draft bill right now, that is, you know, is sitting somewhere on the Legisinfo website, you're not going to find what the text actually currently proposes to say. Because the minister has proposed substantial amendments that really change the whole act and fundamentally make a different style of approach. Originally, they were going to kind of leave it up to the companies to decide whether or not they had a quote-unquote high-impact system, which would necessitate some kind of higher obligations of regulation or at least self-reporting or policy. And what they've now shifted to is a little bit more of a prescriptive model that defines what types of systems are high impact, and therefore does that. And so, you know, a high impact system would be, you know, the types of things you would expect to see in there, you know, things that deal with law enforcement or court decisions or emergency or healthcare services, of course, high impact. Some other ones that are maybe less intuitive, you know, prioritizing or moderating the presentation of content. So that's clearly directed at the, maybe search engines and social media companies. And there's another one that speaks to determining whether or not to provide services and the types of cost of services, which might be directed at some of the app-based pricing mechanisms that we see, or dynamic pricing models. And so, we'll see what the list looks like. The other thing about ADA is a lot is left to the regulations. There's a lot of framework in there, and then to be decided in the regulations. The regulations themselves haven't been promulgated yet.
Well, thanks, Ryan. Carrie, apart from Bill C-27, are you seeing any other legislative or regulatory changes in other areas of law that will impact the use of AI by businesses here in Canada?
We have seen a change in the Ontario Employment Standards Act, and this has passed, but it's not in force yet. The new requirements under the ESA provide that all employers who advertise posting publicly and who use AI to screen or assess or select applicants for the position must include a statement saying that they are disclosing the use of artificial intelligence. As before, these requirements aren't in force, and we're not sure when they may come into force. This new section is subject to additional criteria that's going to be governed by regulation, and the regulations have not yet been released. And so we do recommend continuing to monitor what will be happening here. In addition, Ontario has also released new legislation that governs the use of AI in the public sector and impacts public bodies governed by MFIPA and FIPA in Ontario and their use of AI. Those are the two key legislative amendments. In Quebec, the use of AI often really relates to automated decision making and those restrictions under Quebec's privacy law. And the commissioners in BC and Alberta have also considered this issue, and the BC commissioner has issued guidance on the use of AI.
Yeah, I think it's really important to remember that the use of AI, when you're thinking about rolling it out in your business or integrating it in some fashion, you do have to be considering the existing regulatory frameworks, which, even though they don't specifically apply to AI, they certainly do. For example, in the employment context, the impact of AI on making decisions about people and whether or not it's touching on any protected grounds under human rights code or existing privacy rights that folks may have under either provincial or federal privacy legislation. So I think that sometimes can be lost a bit in the search for new regulations, or as new regulations are coming in, is the applicability of the existing regulatory frameworks to this new technology. It certainly applies. So thanks for that on the regulatory side. I want to turn to litigation update. So Shea, as we're waiting for these new laws and regulations to come into force, how is the litigation impacting businesses' use of AI today? What's happening on the litigation side of things here in Canada?
Yeah, thanks, Tyson. So I guess I think it's helpful to remind oneself that intelligence is not a monolithic thing, and it's not like artificial intelligence is unitary or monolithic. And the reason I say that is because the litigation landscape really depends on what you're talking about, right? Like, what is the tool at issue? What type of artificial intelligence are you talking about? Because it's leading to different kinds of litigation risk, right? So for example, we've had like traditional classifier AI, predictive classifier AI for some time, and there's already been litigation with respect to that kind of AI. Like, for example, in the United States, there are credit rating companies that have faced allegations of discrimination as a result of bias in the use of these classifier AIs, and that's led to a very significant overhaul of some of these AIs. The classifier AIs, there's new algorithms being developed and audit tools being developed to target bias and discrimination. So bias and discrimination is a live risk. It's been litigated in the United States, and it continues to be an important subject of both litigation and the regulatory environment. I think with respect to generative AI, one of the major problems is the difference between what generative AI actually is and what it is perceived to be. And that gap is creating significant risk and significant litigation risk in particular, both for internal users, because if internal users may not fully understand what AI is and its limitations and its capabilities, then they may rely on it to do things they cannot reasonably that it cannot reasonably or accurately do. And then on the public-facing side, it's the same kind of problem. If Gen AI is presented or understood by a customer or a consumer to be able to do something that it is actually not able to do, that creates liability. And I think the famous example in Canada is the Air Canada, this tribunal case. It's a very small tribunal case. It's not a significant amount of money, but the principle is there, and it illustrates the point, which is there was an AI chatbot that Air Canada used as customer facing in order to answer customer questions, including questions about their policies. And a customer made a decision on the basis of AI advice from that chatbot, but it was actually not fit for purpose because it gave incorrect advice. The customer relied on it, suffered a loss, and was able to recover at the tribunal. So that's a good example of the deployment of a tool where perhaps the risk management for the consumer misunderstanding what the tool is able to do, or maybe even the team deploying it, maybe some sort of created some kind of risk that ended up in a tribunal. We're also seeing interesting developments on the regulatory remedy side, so regulatory litigation in the United States. There's the Federal Trade Commission that has created a new remedy called algorithmic disgorgement that was actually used against a large large pharmacy that was using facial recognition technology to essentially prevent shoplifting. There was a complaint about bias in that technology, and the FTC investigated and ultimately issued fines and disgorgement of the algorithm that was conducting the facial recognition, and a 5-year ban on the use of facial recognition technology for that pharmacy. Very, very serious implications. Obviously, I don't have all the time in the world here, but we've got IP and copyrights being litigated in the US. That's active. There's defamation claims now against some of the generative AI foundation models for alleged defamation coming out from some of these chatbots. And I think also it depends on the industries or where the risk is going, where the litigation is going, because for traditionally risk-averse businesses, such as us in law, we are not seeing as much aggressive rollout of sort of new AI capabilities. It's happening, but it's a little bit slower because the landscape isn't known. With respect to, say, financial institutions in Canada, they are concerned with the upcoming OSFI guidance on model risk. They've dealt with traditional model risk, but there's new regulatory guidance coming out for that industry. And the fintechs that kind of go on the back of these large financial institutions are kind of watching. They're regulated less, they're watching, but they're worried about litigation respect to discrimination in particular in crediting decisions and that kind of thing. So I think that's kind of what we're seeing. It's really nascent. It's hard to predict where it's going to go. We don't truly know the standards of care that are going to apply, but there's certainly risk of negligence, and it's an uncertain environment. I don't know, Ryan, if you have additional thoughts, because we were talking about this just the other day.
Yeah, I guess I would just add, I think it's really important. The reason that it's really important to tie what the regulators are doing and what the litigators is because AI is marching on. Companies are marching on using it despite these risks. Because the market forces are such, and the need to grab land in the AI space is so hot right now that, like, if you don't move ahead, you can't really wait for the courts to settle this or the laws to come down. And so people are trying to make informed decisions. But I think a big aspect of how people will use AI is driven by this uncertainty in both regulatory and litigation. And I kind of like to remind people that, AI is a very, at least the AI that people are thinking of now. AI is very old, but the AI that people are thinking of now is a relatively recent addition to all of the industries in which it's now infiltrating. And in those cases, it's not necessarily coming from a place where people are just assuming they can do whatever they want. One of the biggest differences that I've found that companies are approaching AI with is it's a lot of caution. You know, when the big players started to roll out their AI tools, and certainly we've experienced this at a law firm as people try to sell AI tools to us, and a lot of companies face this as all the big started to sell AI tools to them. You know, they were hitting a lot of resistance from the CTOs and the privacy officers and the people and the folks in charge of stewarding the information of a company, saying, wait a second, we don't necessarily want your AI training on our data. We don't want to give you cloud access to all this information. So that resistance or that slow creep that we're seeing, it's coming, and it's coming really fast. But it's actually not nearly as fast as it could be if people were just willy-nilly doing whatever they wanted, right? There actually is a level of restraint in the AI industry right now, which we haven't seen in past technologies. And so it's a really interesting time, I guess, right now, in between the resolution of a lot of litigation results and regulations, at least in most jurisdictions. There are some jurisdictions that have been quite forward on their AI regulations. Canada is not one of them. And so we're in this really weird in-between time where we're moving forward anyway, and we're trying to, you know, assess how that works.
Yeah, I like that comment, Ryan, and I think it's kind of why I mentioned earlier, it's both industry and tool dependent. So these higher risk industries are being more resistant, but say I've seen a lot more marketing departments, for example, playing around with Gen AI just for ideation, and that's proliferated a lot more than say lawyers trying to use it for legal research, which is, you know, we know where that's gone, and it hasn't gone great so far. It will work, but yeah, that's the point.
That's a good segue, actually, because speaking of some of these higher risk uses, one of the ones I wanted to touch on is the use of AI tools in creating content or other intellectual property. You know, two of the primary concerns, and there's more than two, are you know, whether or not copyright or other protectable intellectual property rights can exist in works that were created by AI, what AI even means or what it means to be created by AI, and the unintentional inclusion of protected works in outputs from AI tools due to being included in data sets used to train those AI tools, ultimately leading to inadvertent infringement of third-party IP. There are many other concerns, but Ryan, for businesses which are creating new IP and content, what should these businesses be considering when developing, you know, effective and practical policies for the use of AI tools in IP creation and content creation?
Sure. I think I would start with the position that, you know, it's probably naive to have a no AI at all policy and just assume that your job is done in today's world, because you know, as Shea was alluding to earlier, we're not really dealing with artificial intelligence as some monolith. There's quite a continuum of what people consider to be artificial intelligence, and there's quite a continuum of what processes and machine learning techniques are used inside of those AI tools. So some things that might seem like, I was personally amazed when WordPerfect came out with a grammar check way back when. I thought that was pretty intelligent. That was pretty cool to me, that it was checking my sentences and making sure I was using grammar properly. Is that artificial intelligence or not? I guess it depends on your definition, right? And so one of the biggest things to understand is that you need to really scope out what you're trying to address in your policy. The other thing you really need to scope out is an inventory of what risks apply. And you have to start from a top-down level. You have to start at the top of the company and make sure everyone's aligned with the idea of what's the purpose of our AI policy, what's the purpose of our potential use of AI, where do we want to use it and where don't we want to use it, and most importantly, why? Are we addressing company risks? Are we addressing legal risks? Are we addressing financial risks? Are we trying to be ethical? Are we trying to, you know, succeed in our corporate mission? How does it align with our culture? How does it align with our bias? You know, one of the advantages, Tyson, that I think you and I have working in the games industry is that we're in this kind of partial tech, partial creative industry where AI is this incredibly divisive thing at studios, because on the one hand, you have the tech people who are enamored of this new technology that they can play with. And on the other hand, you have creatives who are like, I don't want an AI creating art. That's my job, right? And so you have like a really interesting dichotomy at the studio level that kind of means that when you're rolling out an AI policy, it's so apparent that you can't just have like this, we're going to do this, without considering how it's affecting your workers, how it's affecting your consumers, how it's affecting your partners and your legal and regulatory environment. Of course, it's really important to have a written policy and to consider who's going to be responsible for it. And so that's really key. And to also make sure that it doesn't just address, things like sometimes it just sits on the privacy officer's desk, and that's probably not good enough. It needs to go to all levels of the business, right? This isn't just a privacy issue. It's a big part of it for sure. Most AI tools are cloud-based, which means a lot of data flows back and forth. So yes, data privacy and confidentiality is a huge part of it. But, I think some of the risks that Shay's already alluded to, you need to maybe have some transparency and explainability about what your AI is doing and how it's doing it and how it's ending up with the results it does. You might be accountable to people for the results of your AI, right? So you need to maybe address some accountability and responsibility. Tyson, you mentioned the IP issues. That's another big thing that your policy should really address. How are we going to deal with making sure that we know the provenance of the materials that we're likely committing to other people we own or that we have the right to use? Of course, you want to comply with laws, but then you need to train people and make people aware of what AI is and what it's doing, and most importantly, what it's not doing. You can't be relying on AI for actual intelligence right now. The types of tools that people are developing are not intelligence in the way that Shea, myself, Carrie, and Tyson think of the word intelligence. They're intelligence in the sense that they're doing things that we used to think you needed some sort of intelligence to do, but it's nothing like human intelligence. And so you really need to train and make people aware of that. Of course, you also need to audit and monitor to make sure that your policy is being effectively implemented and that the policy is actually addressing the facts on the ground. And of course, like most policies, you also have to include what happens if things go wrong? How are we going to remediate problems? And most importantly, how are we going to hold people accountable for not doing what they were supposed to do with AI? Because when those lawsuits come or when the regulator comes knocking on the door, you don't want to say, I wasn't aware of it and we didn't do anything about it.
Absolutely. I think those are all very good points. I really want to stress how important it is to, it's not just a simple set it and forget it with the AI use policies. And it's really important to have proper training so that people can actually understand what it is that you're talking about when we're talking about the use of AI. And as part of these rollout processes, Ryan mentioned kind of involving all aspects of the business so that you can get that good feedback on how your teams are already using the AI tools before the policies are in place, because that's almost certainly happening. Or they may not be thinking that they are, but now that you've set clear definitions and are trained people on those definitions, they now understand, oh, these tools do apply to the definition. So these are things that are really important to do to ensure that your policy is actually being used properly and is effective. One of the things that you touched on, Ryan, is the morale aspect. And I'm curious if you have any kind of thoughts or strategies on dealing with that. I know that's a bit more particular perhaps to artists or creatives, but I think that there's a lot of, as we've seen with the strikes that have happened on the content side in the US, it's a very sensitive issue. So any thoughts on kind of managing those kind of morale risks?
Yeah, I think that like most tools, AI is going to make us, the productivity graph, if you look at worker productivity over time, it generally marches upwards, and AI is going to continue that trend. It's going to help us be more productive in our jobs, and it's going to help us do more. But there is going to be a sense of some people and a truth for some people that it's going to be a bit of a replacement. And that's just a reality that we're going to have to deal with. Like if your job relies on a menial repetitive task, at some point, maybe it's AI or maybe it's just automation. At some point, you might be replaceable, right? And so a job needs to, and what these new quote unquote AI algorithms are doing is really sophisticated information processing that allows them to do things that we would traditionally think of as creative, right? Like generating a new image or generating a new song based on material it's seen before. And the degree to which that's similar to the human process, we haven't even really begun to explore. But obviously, people get an innate sense, hey, am I being replaced here? Is this something that's going to take my job or my livelihood? Is this good? Is this art? Is this what we're in the business for? And so, for example, in the games industry, I've told people, just because people don't like AI or just because it's got this controversies around it doesn't mean you should ignore it or say no to it, because it definitely could lower development costs. It definitely could lower iteration time. It definitely, it could have all these effective benefits that we want it to have. And it can be sensible to use it when it makes the product better, or when it makes the process of making the product better, when it makes your business better, when it makes your business more reliable, when it helps people do their jobs, right? Like that's the sort of thing that you can sell to someone. If it helps you lower the cost of production so that you can invest in other areas of production, that also can help you sell it to your community. The other important thing to keep in mind is that there is a sense of equity and bias with AI that is really apparent that isn't apparent with many other algorithms. So if you tell it to generate an image of a doctor and it only generates older white males in the picture results, people are going to realize pretty quick that it's biased because we're visual creatures and we're going to see that, right? We're going to notice that really, really quickly. An algorithm, Shea, you mentioned before there was some algorithm disclosure issues in a litigation file. If an algorithm does a thing, you might get to the bottom of it eventually, but the bias might be a lot more hidden than it is with AI, with these types of created types of AI. And then the last thing I would say is don't just think about one set of stakeholders, right? Like in the games community, for example, you don't only have to care about your employers or your employees and your contractors. You have to care about what the platforms think. You have to care about what the game consumers think. You have to care about what the trade publications think. You have to care, about what the regulators think. Like your stakeholders are broader than just the people that are going to be using the AI.
Speaking of morale and employees, Carrie, I'm going to turn things back to you. So for businesses that are looking to use AI to hire and manage their employees, for example, doing first passes of resumes and cover letters that may be coming in, or other types of management tools. What do these businesses need to consider when doing so? Are there common issues and pitfalls that businesses should be aware of? Are there certain issues that they should be running through as a checklist of sorts before rolling anything out?
So it's not just in the recruitment, but also in the management process that we've been seeing issues that employers really need to think through with the new tools that continue to develop and continue to be available. We talked previously about human rights risks, and because of the sensitive nature of the information that the employer has to manage, particularly medical information that employees may provide in order to, seek accommodation in the workplace. There may be certain demographic information that is collected for certain. There's limited statutory reporting obligations in Canada, but in BC, there's a new obligation to collect gender information under the Pay Transparency Act. But there's also strict restrictions in terms of what employees need to be notified about and how that data is used. Also, DEI initiatives, we usually make recommendations about how that data is managed to protect the employer from human rights complaints, both in the application stage, but also throughout the entire employment process. And we often, recommend segregation of that data, so the hiring manager is not, and nobody on the hiring team actually has access to that data unless there has been a very careful and thoughtful program put in place that specifically is compliant with human rights legislation in the various provinces. The tools that are available to employers nowadays are amazing, but combine data in ways that maybe hadn't been available before, and in ways that create new risks. And sometimes are presented in a way as, don't worry, this is actually anonymized, but it's not anonymized at all, right? And we see tools where the applicant, there's clear disclosure. You can clearly identify all kinds of information about the applicant that would be considered a protected ground under human rights legislation, and the hiring manager sees all of that. But the tool is presented as, don't worry, it's anonymized, it's randomized, it's anonymized, but it's not in the way that's necessary to meet compliance with human rights law and privacy law in Canada. So there just needs to be a real careful scrutiny of the actual tool. Who sees what? Who has access to what? Like, what are you implementing? And the new capabilities are amazing and exciting, but but maybe we need to segregate some of those exciting new capabilities, again, to ensure that we're protecting the company as a whole from certain risks in the human rights regime and privacy complaints.
Yeah, absolutely. I think that's very key. I know, Carrie, you and I have worked on a number of technology procurement projects for clients. and you see the initial pitch deck coming in from a vendor or representations on a vendor's website, and you're comparing it to the commercial terms of the actual license agreement, and they often don't align, or they're using terms like anonymized, which now have a specific legal meaning, but they're not using it in that way. And it's just really important to drill down, to do careful reviews of these license agreements, to ensure that the proper protections for your employees' personal information are in place, that there's not over collection of employees' personal information through these tools or through applicants, for example, that you're considering things like obligations to delete data, especially if data is going back to vendors and those vendors are purporting to own that data that is going into their tools, and what that looks like and what those risks are, and making sure those uses are being properly communicated to employees through revising your employee privacy policy, which is another oft forgotten step once new AI tools, or frankly any other tool, is being implemented in the business. So those are certainly key things. One thing I'm kind of curious to get your thoughts on, Carrie, is one thing I've seen is in our more for industrial clients or clients that are warehousing and things like that, I've seen a lot more AI tools being used in the realm of worker safety. For example, seen tools that detect drowsiness in drivers, or people kind of being off, etc. Any kind of thoughts on these workplace safety AI tools in particular? Are there any particular concerns involved in those?
Yeah, so those need really careful vetting. They can be very effective workplace safety tools, but particularly in the unionized environment, there's a whole very long history body of case law that applies, and also some of those tools trigger the case law on drug and alcohol testing, because some of those tools are also like sort of being presented as proxies for drug and alcohol testing, and trigger a whole the whole body of case law there. So they need careful vetting. They can be helpful tools, but through the procurement process, you may need to say, okay, we're going to implement this particular part of the tool, but not that, and you need to really look at who's your employee base, what are we using this for? Do we actually quote unquote turn everything on? And what is the risk, particularly in the unionized environment? So
very good point. So it seems like a lot of these, privacy is obviously a huge aspect, and it is a privacy symposium after all. So Carrie, continuing to pick on you a little bit here. What are some of the key questions that businesses need to be asking themselves, before licensing an AI tool for use in their business, from that privacy perspective? Are there particular things they need to be looking at when they're, reviewing a vendor's data processing addendum? Hopefully they have one in the first place. What are some things that businesses need to be thinking of?
Well, so first, first and foremost, are you actually going to be using the tool to process personal information, right? And carefully thinking about, is that information going to be used to train the AI model? What is your business, right? If you are in there may be certain industries that the personal information that you have in your custody and control should not actually be used to train the AI model. Are we looking at simply having a specific instance that's only for your use? Secondly, when we're thinking about I would recommend a fulsome privacy impact assessment on any tool. And to Ryan's earlier comment, yes, these obligations are maybe not 9 times out of 10, but in many cases landing on the privacy officer's desk, because the privacy officer for the organization has sort of an established process for assessing new programs and assessing and assessing management of data, and so at the same time as you're doing the fulsome privacy impact assessment, this is where you can be reaching out to your other stakeholders and adding the extra levels of assessment on the additional factors that you need to consider for, for IP, for litigation risk, and so on. I would say look at it as a more wholesome, like whole scale analysis beyond your traditional PIA. But you definitely need to be thinking about, what personal information are you putting in there? Should you be putting it in there? And what are you telling people? What are you notifying people about what's happening in there? And then just one other practical issue is that individuals have a right under our privacy law to access the personal information that you have under their custody and control. And so depending on the operation of the particular AI system model, whatever you are implementing, there's a possibility that you actually can't give effective right to those access rights. So you need to really think about that as well. If somebody says, I want to know, I give me my personal information, you need to be really thinking about, can I do that? Right? If you receive an access request, you receive a correction request, you and or in Quebec, you're receiving a deletion request, or the additional subject requests that are in Quebec.
Oh, absolutely. And one of the things that I often have to kind of wrap my head around sometimes for some of these tools that are going to be rolled out internally within an organization is oftentimes the vendors are trying to have contractual obligations between the vendor and our clients' employees directly, which is a fraught issue, and trying to work around those things. To make sure that the business is actually properly placed between the vendor and the employees is a key thing as well. We have a question in here, which is particularly relevant. What is the current position regarding the location of cloud storage facilities and information processing outside of Canada, and the risks inherent, including with different legal and regulatory regimes? So I guess data sovereignty, when should we be concerned about it, and how can we deal with that in data processing addenda or the agreements generally?
So in the private sector, there's no prohibition on transferring and processing data outside of Canada, so long as individuals are properly notified that processing, notified in advance that processing will happen, and that the data may potentially be accessed by government authorities in accordance with local law. The exception is that in Quebec, there is an obligation to conduct a privacy impact assessment before data is processed, not just outside of Canada, but outside of the province of Quebec. In the public sector, there are some additional requirements, and that they're very specific by statute, by jurisdiction. They may require privacy impact assessments before data is transferred outside of the province. Certain personal health information legislation may require various assessments or commitments about technological security before the data is transferred outside of Canada. There's no, at this time, no blanket prohibition, but there may be certain compliance steps that need to be taken.
And maybe I can just jump in with one quick comment there. While not yet enforced, as Ryan was mentioning, the EU AI Act has been passed, and we will eventually have AI legislation. And I think the risk assessments that will be required under whatever form that legislation takes, whether it's at additional agency level or federal level, or there's a unique regulator set up, will engage that issue as well as on the privacy side for sure. And it'll be a use case risk assessment. The federal government, for example, has an internal guideline for federal agencies where they have to conduct these impact assessments already going forward. And this would be one of the factors that would be considered. So I think this is good. That data sovereignty thing is going to grow in importance.
So Shea, actually a question for you. Zooming out to the organizational level. So in addition to kind of all the issues that we've been discussing with Ryan and Carrie here, what do boards and C-suite executives need to be considering when greenlighting the implementation or development of AI tools and systems in their businesses? What should as fiduciaries of the business, what do they need to be thinking of?
Yeah, well, I'll go through kind of a few like sort of practical steps that we generally have been recommending, and it's starting to become more industry standard. I think one of the key problems though right now, well, there's two key problems that I've seen. One is the risk control framework needs to be an enterprise-wide risk control framework with respect to AI, and that's not necessarily where most organizations are at right now. It's sitting on one or another individual's or department's desk, but it's not enterprise-wide. Regulation is going enterprise-wide, and I can say, for example, OSFI, the federal financial regulator, is requiring enterprise-wide risk management for the deployment of all models. So on the second issue is I was just talking at a conference, the Governance Professionals of Canada, and we're doing a bit of polling and looking at both Canada and the US, and it seems like it's maybe only around 15% of companies that have policies in place right now for AI, so those are big gaps. Okay, with respect to kind of the steps here, the foundation of effective governance is starting at the C-suite, the leadership level of the company, to set a strategic vision for AI and AI use in the company that is underpinned by the core principles that we now know from all the regulations that have been developed. So, ethical use, trust, oversight, legal compliance standards, and that's sort of the top-down strategy that drives everything. And the buy-in from the C-suite is very, very important, and it seems to be linked with effective AI deployment versus maybe some challenged AI deployment. The next step would be, set up a day-to-day organizational structure that will take that strategy, they'll implement it on a tactical level. So that's where we're talking about policies, guidance, approvals for the use of tools. You're going to obviously want to slot the AI governance into existing risk control structures, but we are seeing, especially where AI is a serious issue for organizations, the setting up of a committee, a specific committee to deal with AI risk that addresses and approves various concerns, deals with the policy, reports back to the board, reports to fulfill the board's fiduciary duties through, the officers. Then the really important step that Carrie has been mentioning a lot of is identifying the use cases and the risk profile for each specific use case. They're not all the same. Some are high risk. All the legislation is classifying use cases into, high to low risk, and there's different regulatory requirements. That's a good baseline, but each organization is going to have additional specific risk profiles and industry-related risk that Brian was talking about, with the games industry, where you have this huge list of stakeholders. So the regulation is not going to tell you the answers to all those questions, which is why that risk framework, or your risk assessment framework, should be built on top of the regulatory framework, but bespoke to your business and your industry, and then bespoke to the specific use cases. So, if it's a high risk use case, maybe a certain kind of tool, because it's a black box tool that you can't explain, is actually just completely inappropriate and you shouldn't use it, versus low risk use cases. And then there's the unintended effects that should be considered. For example, AI transcription tools. As Ryan knows, I'm dealing with a case now, and I've seen this many times, where board meetings have been transcribed by AI tools, and suddenly that's evidence in litigation. And maybe you didn't want all of that to be evidence in litigation. So there's the unintended effects. After sort of assessing those use cases, you definitely want to consider whether any of the outputs from your AI use or your computer systems will be used in the EU, because that's going to be captured by EU law, and that's more common than may be realized. And then categorizing into those risk profiles, and then setting up the controls. And there's generally a series of controls that seem to be consistent and work pretty well. So there's the monitoring and oversight, human in the loop for AI tools. There's, if necessary, a data science assessment for bias for certain uses, impact assessments to preemptively address the likely effects of the use of that tool. Carrie mentioned training, upskilling of users, operational controls to ensure the effectiveness of the tool, technical measures and contractual controls for vendors in the procurement of AI, because as I think you mentioned, Tyson, there's a lot of differences between the marketing and the actual commercial terms. And so, you need those contract controls in place in order to set up a proper procurement model where you're not simply importing significant amount of risk from the vendor that is selling you that tool or collaborating with you in order to develop maybe a hybrid type tool. And there's a whole other list of stuff under contract control, but I'll just sort of end it with the final point of stay up to date. This is changing all the time. You'll be out of date in a week. And that's one of the reasons why the committees focusing on AI are really helpful, because you have a dedicated team that is focused on staying up to date and being aware of what's going on.
Thank you very much. Yeah, we'll actually talk a bit about contract control. So we got a good question in here for at the end during our question period. So the last little segment I wanted to do here is a bit of a lightning round, a prognostication lightning round. It's asking each of you just to very quickly opine on kind of where you see AI regulation in Canada kind of going in the medium term, let's say the next, like, I don't know, 3 to 5 years or so. Ryan, why don't you go first?
Sure. I mean, my guess would be that whether in this government or in the next government, we will see some sort of principles-based legislation coming, and that because it's so hard to prognosticate where AI is moving because the tools are iterating so fast, I do think that a principles-based approach is going to be a little bit better than a prescriptive approach. So I'm not sure that the current direction that tends to prescribe things a little bit more is going to be the right way. I think that we can look to certainly, we probably don't want to look to necessarily the lack of teeth that our privacy laws have if you're worried about the risks of AI. But in the very least, the principles-based approach for privacy has actually worked very well in a number of jurisdictions. And so I think that what we're going to see is that, coupled with the fact that people are going to use this thing, and I don't know that it's going to matter that much what Canada's laws are going to say, being frank, in the world. People are going to try their best to comply, and certainly Canadian companies are going to comply, but we have to be careful not to hamstring our Canadian companies as well if the rest of the world is moving in a different direction. So I do think that the global movement is going to matter a lot more than the Canadian movement, and probably will inform where this law ends up.
Yeah. Gary?
So my prediction is that the provincial regulators will wait to see what happens federally. We talked about what is already in place, and addressed in Quebec and pending in Ontario. But otherwise, I anticipate that provincial regulators are on pause until we see where we end up federally. And then to the extent that there are complaints to the privacy commissioners, for example, about this, they will be, interpreting any such complaints under the existing statutes and existing principles. Similarly, if there's complaints to the human rights commissioners, they'll be looking at existing principles. So.
Awesome. And last one is Shea.
Yeah, I think of a similar theme. Reactive is how I would describe Canadians' approach, the Canadian regulators' approach to this. I think we will see a lot of the responses develop at the agency level, practically speaking, as we're already obviously seeing with privacy, as these issues are just going to be forced on them and they're going to have to think about them. I'm not sure how long it's going to take the federal government to actually pass any form of legislation. And in the meantime, it doesn't matter because the EU has passed it, and like compliance with EU law is being put into contracts. We see those in RFPs, regardless of whether it's for a European service provider. Canadian service providers are having to agree to comply with EU AI Act requirements. And so I think what we're going to see is a lot of commercially driven change, organizational change, and then there will be reactive litigation when the problems arise, and complaints to regulators that lead to maybe a little too late assessments and creation of rules. And I can say, for example, professional regulators ought to be doing, in my view, it's just my personal view, it's not the view of VLA, but they ought to be doing more than they're doing and there's certain industries where, you know, the software is so advanced and impactful, and the regulator is not so concerned with that, but it's the software that's being used day to day by, say, engineers. As an example, we know that there's generative AI built into almost the suite of almost all products, but there's no regulation by the professional regulator about what that means. And so I think we're going to see reactivity, and then there'll be the big class actions out of the US, and they'll come up here.
Awesome. Thanks all. We have a few minutes left here at the end for some questions. There's one question here, which I think we could easily spend an hour on alone, but I think we can get some few comments from folks. The question is, would love to hear your perspective on the negotiation of SaaS contract terms on behalf of customers. And if I may, I'll say a little piece first. I do a ton of software procurement work for large enterprises. So I've seen the good, the bad, and the ugly in terms of vendor agreements. I think on a first stage, what I'd like to see from the customer side is that the vendor has actually thought about it and has actually put some time and effort into drafting a coherent agreement, one that covers the common issues, including all the data privacy aspects, whether that's covered in the body of the agreement or you have a separate data processing addendum that is thoughtful and considered, that is not for ones that are, you're negotiating specifically with enterprises and you know that your customers are actually going to be reviewing and negotiating agreements. They're not simply click-through agreements, that they're not entirely torqued to the point where you know that the in-house legal is going to be, you're going to be getting a giant red line back every single time that you're throwing your agreement at one of your customers, so that you can actually get the deal done and your sales team can hit their quarterly targets. I think those are, at least at first blush, those are some of the things that, that's the first thing I see. I don't know, Brian or Carrie or Shea, if you have any thoughts on this one at all.
I'll jump in and just actually tie it to a question that's actually below as well from our good friend Samson, who's asked about, kind of the preventative practices to minimize the risks of using AI tools or vendors. And I think that the practical thing when you're negotiating these things is the paper won't fix your problem if AI goes bad. The paper will create a liability trail that you'll be chasing, and Shea and I are currently chasing all sorts of things right now on the litigation front on behalf of some clients. But ultimately, the paper isn't what protects you. The practice is what protects you. So I really like that question, because what we're seeing and what the big companies saw as they started to try and roll out their AI tools to the company is a really slow approach. We don't want you to access our data, number one. And then the AI tool kind of needs the data to do its job. And they say, okay, well, then you're going to create a sandbox for us and we're going to control the data. And then the AI providers are kind of like, well, maybe we can't do that because, these technological reasons or whatever. And then they say, well, okay, maybe we need a kill switch or pull plug function of the software that allows us to effectively create a wall around our data so that we can pull it out of the product if and as we can. And you're creating these technological limits around what people can do with the AI. But the practical reality with how these information and Shea, we didn't get to talk about your philosophy point earlier, but I do think of them as information processing tools, and they are just information processing tools. But the way that these tools work, you really can't pull data out of them that easily. Once the model is trained, it's kind of trained, it's kind of all in there. And so there may be a technological solution in the future, but if your data or if something you don't want confidential, or say a customer's privacy information or whatever, ends up in someone else's AI database, that could be a lifelong problem that you're dealing with.
I think that's a really good point. And I agree that it's the organizational governance and risk control framework that is going to be the greatest protection versus the commercial paper, at least based on what I'm also seeing, and that it's difficult sometimes. I'm curious, Tyson, you've had some ability to go back and forth on this, because it's difficult to negotiate some of these agreements, particularly with very, very large businesses that may be offering foundation models. So, how do you deal with that? Well, that's where the governance comes into place. And I really think, I know our US office is very heavily focused on governance, and they're doing a lot of work in that area. And like again, that governance professionals conference I was at, this is like the #1 topic that a lot of these consultants are being asked for advice on from boards, is how do you set up the governance? And that's because you need that control framework to mitigate the commercial risks of the deployment of the tools.
Yeah, I can speak quickly on that, because I do think some of the largest vendors in this space are doing a better job in terms of, because they understand that when they're trying to sell their products to chief legal officers and privacy officers at their potential customers, that they need to assuage their concerns about all the risks that we're talking about today. And it's going to be very particular to the tool. I know there's a question here about generic language. It's very hard to have generic language because the tools vary so much. You really need to be thinking about, what does this tool do? What are we concerned about? What are we giving them in terms of information? What are we getting out? What are we doing with it? So it's hard to kind of have generic terms. But I do think that in terms of what makes a good one is that some of those larger suppliers of this software have thought through it, and they've done things like provided, specific indemnities which address very key concerns. For example, the third-party IP infringement concern. There are suppliers that provide indemnities specifically for that, provided that you're using certain guardrails that are built within their system, et cetera, et cetera. And so those, by thinking, putting yourself into your customer's shoes, what would my customer be concerned about? What are their legal risks, and how can we reasonably assuage those concerns while obviously protecting ourselves as the vendor of the software? That's how you create a good a good agreement that is actually helpful and to a customer, that will hopefully reduce friction, kind of tie it back to that kind of original question there.
Can I flip back a question to you, Tyson, as the moderator, which is,
sure.
what do you think, or how do you think the developing regulatory environment, like the EU AI Act in particular, can be used and is being used to leverage terms in a commercial negotiation?
Well, it's pushing it, right? The EU is kind of, and it's done this in a number of different areas, is that the agreements that we see are almost always tailored to EU law. And so it is kind of forcing the hand of some of these big suppliers to bring in terms which are either more clear, maybe a bit more, I don't know if equitable is the right word, but it acts as the EU's regulations in a number of areas have always kind of pushed these vendors towards providing more detailed terms. I don't think without the EU's laws, I don't know if we would have even seen a data processing addendum, but now we have them. I mean, they're ubiquitous. So I do think that that's going to be, as far as regulatory pressure, it is coming from the EU, and big businesses and small businesses do respond to those pressures, and they're reflected in their agreements.
If I can just also quickly jump in, we also have to remember our good friends to the south, where they have 50 different jurisdictions and one big jurisdiction that is all separately passing laws and rules and regulations right now, some of which are incredibly overreaching and some of which are incredibly narrow. And, you think about, for example, we've had this experience before in the privacy space. Illinois has a very, very strict biometrics data processing law that a lot of the rest of the US doesn't. But as a lowest common denominator, companies that want to sell in the US kind of have to pay attention to it, because that's how it works, right? So we're going to be paying attention to a lot of different regions. And the law here is moving really fast. I think there's something like, I don't know, like 21 bills in the California alone right now dealing with AI. Like there's a lot happening.
Well, that brings us to time, and I think just kind of the closing statement of there's a lot happening is probably a good way to wrap things up. So thank you very much to our panelists for joining us today and sharing your insights. Thanks to all of our guests for attending and for your wonderful questions. If you have any follow-up questions, please feel free to reach out to any of us. Would be more than happy to sit down and chat about any of these things. So thank you everybody for attending today, and have a lovely rest of your day.